兄弟之间在合作之初，也要把有关的规则说清楚，避免将来合作不愉快。各个国家都应该严格的遵守国际法，包括历史形成的国际惯例，信守承诺。金砖国家应当建立法治共识机制，常态性的开展法律交流和法律理论的研讨，近距离的观察各国的法律实施的运行的状况。当存在分歧的时候，要运用法治方式进行处理，通过达成法治共识来消除误解，来搁置分歧。金砖国家还应当建立实质性的法律合作机制，制定属于金砖国家合作机制自己的规则体系和争议解决机制，从而强化金砖国家合作机制作为重要的国际力量的身份认同，提升在国际事务中的话语权和影响力。金砖国家要加强法律职业建设，不仅为各国及其企业服务，也要为金砖国家合作以及金砖国家与其他国家的合作与竞争服务，让法治共识成为开展合作的支撑性、基础性的共识。第三呢，在金砖国家合作机制框架下，要探索构建一体化的商事规则体系和特色鲜明的争议解决机制。本届论坛在为打造有效、包容、共同的解决方案提供法律框架的主题下，3个议题里头有2个分别是国际民商事法律新兴体系、构建金砖国家统一战略与合作机制的现实需要、国际仲裁与争议解决，构建金砖国家及新兴国家争议解决机制。这就充分地表明了我们这次论坛的主办方和金砖国家的法学法律界已经深刻地认识到，构建金砖国家的合作机制框架下的商事规则体系和争议解决机制对于金砖国家的合作十分重要。任何一种合作机制实质上都是一套规则体系，任何一种合作机制的有效运行都取决于规则体系的包容性、稳定性。建立一套商事规则体系，将为金砖国家及其企业之间的合作提供坚实的国际规则基础。在规则体系形成的同时，能够建立起一套高效合理的争议解决机制，就能够让合作各方吃下定心丸，进而有效地促进合作。建立规则体系和争议解决机制的过程，在一定程度上就是利益的博弈，也是相谅互让的过程。不同国家之间应当平等参与，秉持正确的义理观，兼顾各国的利益，实现各国利益的均衡，使规则成为各成员国的最大公约数。只有这样，规则才能达到，而且能够得到有效的执行。金砖国家的合作机制框架下的商事规则体系应当坚持平等的原则、诚实信用的原则、高效便捷的原则，促进合作机制的开放性、包容性、公正性。金砖国家合作机制下的争议解决应坚持谈判与协商优先的原则。如果谈判协商解决不了，或者双方都认为无法通过谈判协商解决，这样就可以启动仲裁或者司法程序，把仲裁或司法程序作为化解矛盾、定分止争的最后的一道防线。当然，在设计和适用仲裁或者司法程序时，要保障当事国家或者其他利益主体的参与权、选择权、知情权和救济权。第四呢，我觉得金砖国家作为国际关系中的重要力量和国际体系的重要建设者，应当推动国际法治发展的方面要承担更多的责任。1954年，中国、印度和缅甸3个国领导人共同倡导了和平共处的5项原则。 这样成为指导我们国际关系的一个基本原则，至今仍对维护世界和平与发展发挥着重要的作用。事实也证明了，发展中国家，特别是发展中的大国，在建构民主、法治、公正的国际关系和世界秩序方面是能够大有作为的。国际社会的变化与发展呼唤着国际法治的与时俱进，呼唤着一个以国际法治为基础的世界的新秩序。金砖国家法学法律界应更加积极地参与构建和完善国际的规则体系，共同推动国际社会用法治思维和法治方式来认识问题、解决问题，推动各方在国际关系中遵守国际法和公认的国际关系的基本准则，用统一适用的规则来明是非、促和平、谋发展。金砖国家新开发银行、亚投行，它的设立是新兴经济体为促进全球经济基础设施建设、推动国际经济治理改革的重要举措。今后金砖国家应当在全球治理、国际经济金融体系改革等重大问题上密切的沟通和配合，维护好新兴市场国家和发展中国家的权益，继续推动以平等为基础的全球的经济治理，增加新兴市场国家和发展中国家代表性和发言权，努力来实现我们各国在国际经济合作中的权利平等、机会平等、规则平等。第五，我们中国有义务也有能力为金砖国家合作机制提供应有的法治贡献。中国历来重视法治建设，特别是2012年中国共产党召开的第18次代表大会以来，中国的法治建设按下了快车键，进入了快车道。2013年，中共18届三中全会提出了建设法治中国的宏伟目标。2014年召开的中共第18届四中全会做出了全面推进依法治国的战略部署。2015年，全国人民代表大会审议通过的“十三五”规划纲要明确提出，今后5年要努力实现人民民主更加健全，法治政府基本建成，司法公信力明显提高，人权得到切实保障，产权得到有效的保护。目前，中国上下正在按照中央的决策和部署和全国人民大的决定，全面深化改革，全面依法治国，全面建成小康社会。在国内全面推进依法治国、建设法治中国的同时，我们统筹国内的法治和国际法治两个大局，积极参与国际的法治建设，是国际法治的坚定的维护者和建设者。中国积极参与联合国立法、执法和司法活动，坚持通过国际法治来维护世界和平与发展。中国在推进“一带一路”建设战略中，也把法治引领和保障放到了一个突出的位置。中国法学家、中国法学会是中国法治和国际法治建设的一支重要力量。中国的法学法律界愿意金砖各国的同行建立更为密切的合作关系，结成更为紧密的法律共同体、命运共同体，为金砖国家的合作注入我们更多的法治的正能量、新动力。谢谢大家。
Thank you very much for giving such a comprehensive perspective, Mr. Jiping. And in fact, China Law Society has been instrumental in backing the concept of this forum very comprehensively and in very effective manner, and has carried out much of the coordination after the initial meetings. So give a big hand to Mr. Jiping and China Law Society. Now, our wonderful colleague from South Africa, Mr. Nyotsi. We have been blessed with very, very robust colleagues from Law Society of South Africa, first Max Bukwana and now Mr. Nyotsi, stepping into his shoes. Very strong views, very strong beliefs, but all in the right direction to make the world order more democratic and more inclusive. Mr. Nyotsi.
Thank you very much. Last night, I had a long discussion with Max Bokwana, Krish Naidu, and Mr. David Becker. They further requested me to pass their greetings to the delegates and you, Mr. Program Director. They share some common statements with me that the Indian Law Society and the people of India indeed are very, very generous people. I've been welcomed with much appreciation. I've enjoyed each and every moment that I've since arrived here. As all of us would understand, the basis or the key features that brought about an end to apartheid in South Africa were at least three pillars. One was the armed struggle, the mass mobilization, and the international solidarity. The international solidarity was forefronted by India, China, Russia, and Brazil. Those were the key partners in our international solidarity. And it was at that level, because if you look at the time between 1989 and 90, there were some internal challenges within the current ruling party on its own. Therefore, our strength was on the basis of the international solidarity, with China, Russia, India playing a critical role. It is on those bases that we strongly believe that the BRICS legal community is already a success story, because we have already faced more difficult challenges that we have overcome. And therefore, we are convinced that we are on the right direction. We fully agree and support the establishment of the International Dispute Resolution by the BRICS Legal Forum. As you will understand, in Africa, there's recently been a serious outcry, and a number of African countries were even thinking of pulling out of the Roman Statute and the ICC. And this is a hot debate that is still ongoing, even today, even in our own parliament in South Africa, because of the belief that these institutions are too biased against the African countries in particular. And South Africa, as leading in that part of the continent, has to take a lead. So obviously to us, both within the legal profession and the government, the politicians, we are saying we need to have strong alternatives, of which BRICS provide that strong alternatives. However, it remains our commitment that we need to maintain the rule of law, we need to emphasize protection of human rights, and we need to ensure that we maintain the principle of inclusiveness. It does happen that big economies would swallow the emerging economy to an extent that they find themselves having no role. Now, as we establish the BRICS international mediation and arbitration, we ask ourselves which legal system we will be applying. And the answer is not far to seek. Is that, one, we need to strengthen our universities, the links within our universities. We need to ensure that we develop the BRICS law through research and curricula. Those forms the critical aspect, because we'll be guided by the settled principles of law and arbitration. I fully agree with the submissions made by my learned colleagues, by my brothers, that we need to have BRICS law. We can't avoid that. So universities becomes a critical component of the BRICS countries. When it comes to the local firms in South Africa, we still experience serious problems which arise as a result of the legacy of apartheid. Big companies, they continue to overlook black legal firms in their briefing patterns. We have a very unfortunate situation there, where black people are still excluded in the economy. In terms of briefing patterns, few blacks are being briefed. 87% of the state wealth is still with a few. And right now, we are still battling with what we call transformation of briefing patterns which remain astute. And now, as we participate at international level, this does have an impact to an extent. It is on this basis that we say, develop a BRICS law, ensure that the government give maximum support, and this is what I quite appreciate with India, China, and Russia. I can see that there is a much participation by the government. In fact, there is more interest in the formation of BRICS Legal Forum. In South Africa, we're still battling at that level. Not that there's no commitment. As you all know, the South African government is very much committed and is taking a leading role, but there's still a gap which we have to work on and bring the parties together. I briefly discussed outside with Mr. Kumar on this particular aspect, and it was on those bases that we will be inviting him and the delegation to South Africa next year in our AGM, so that we continue our bilaterals and side discussions on this particular matter. And we hope that out of those discussions, you will see a very strong and vibrant South African participation into the BRICS Legal Forum. But as we sit here, we have universities, we have delegation in all sectors, and within the legal education, there are students from South Africa, not now, even last time. There are people that are participating, and we are getting there, and we are going to make sure that we are a key role player within the BRICS. As I conclude, I must emphasize that The arbitration will help to make access, quick resolutions of matters, because at the end of the day, this must not be about individuals. This must be about our people. This must be about ensuring that our people do derive benefits out of these processes. We talk of, this is the language in South Africa currently, we talk of economic freedom. And how do we then make law as the basis for economic freedom? We talk of second transition of our revolution. What is that second transition? The second